Panel continues our discussion regarding acceptance of responsibility. Our panelists include Mr. John Bendzunas, Mr. Ronald Levine, and Mr. Michael Andrews, all of whom have been previously introduced. We'll start with you, Mr. Bendzunas.
Thanks, Judge Pryor. As with many guideline issues, probation officers are often caught in the middle of this appears to be no exception. Throughout the past year, POAG has obtained a significant level of feedback on the Commission's proposed amendment for acceptance of responsibility. The amendment seeks to clarify a defendant's ability to contest non-frivolous relevant conduct issues that have no basis in either law or fact. The amendment also seeks feedback whether acceptance should remain tied to relevant conduct or become an elements-based test. POAG unanimously supports acceptance of responsibility remaining tied to relevant conduct. It also supports the clarifying amendments explicitly permitting defendants to contest relevant conduct where those objections are made in good faith. During the open comment period, various advisory and interest groups criticize the current structure of acceptance as creating a chilling effect, discouraging defendants from making objections to relevant conduct and forcing them to take calculated risks with potential sentencing consequences. In certain localities, POAG is aware of AUSAs who assertively object to acceptance of responsibility in response to factual and or legal relevant conduct objections. We've also observed district judges who follow suit and routinely deny the adjustments following contested evidentiary hearings, which is a pattern that's generally upheld by appellate courts. While we believe it is not an institutionalized issue denying defendants due process, we believe that the outlying courts do create some level of disparity. Make no mistake, they appropriately exercise their discretion under current guideline authority, but we believe the clarifying amendment is necessary to bring consistency across the system. As the sentencing guidelines have evolved in the past 30 years, applications have grown increasingly complex, and there are often shades of gray where reasonable practitioners can disagree. Estimation of drug quantity and loss, mitigating and aggravating role, evaluating jointly undertaking criminal activity, and assessing witness credibility. These are just a few examples where answers cannot always be found in the black and white of an investigative report or a grand jury transcript. Sometimes it takes the defendant's objection to flesh out the truth, which is why it is important that objections made in good faith be kept within acceptance of responsibility. As POAG has observed in previous submissions, the current commentary allows the government to make guideline objections with no worry of consequence, whether the legal or factual merits are strong or marginal. The court simply accepts or denies the objection, and the process moves along. We believe the proposed commentary provides a better sense of balance within the system. POAG has received some feedback that the proposed amendment could produce a more contentious sentencing environment in which hearings could evolve into mini trials. We believe this concern to be somewhat overstated. The pattern of practice in many district courts is already consistent with the spirit of the proposed amendment. While extending this level of due process can take more time, we do not believe it to be overly burdensome. There are still limits, and when a defendant's objection to relevant conduct is completely unfounded or fits within an overall pattern of frivolous minimization, courts still have the discretion to respond appropriately. POAG ultimately views this amendment as an opportunity to reduce some level of disparity in the federal sentencing process. We believe the proposed amendment provides increased clarity that recognizes the complexities of sentencing, that defendants can make reasonable relevant conduct objections and still demonstrate contrition. Ultimately, a relevant conduct objection should not necessarily be a threshold determination in every case. It should be one of several factors considered in the totality of the circumstances. And that's probably one of the most significant aspects of this amendment that hasn't really been discussed in the open comment period. Application 01A is a threshold determination. Someone is deemed to have falsely contested or frivolously denied relevant conduct. The court can in its discretion, full acceptance of responsibility without looking at any of the other factors. By taking out that last line, acceptance of responsibility becomes a totality of the circumstances test. So if you have a relevant conduct objection in this new system, the court looks at that objection and determines whether or not it's reasonable or fits within some sort of criminal thinking pattern that may be related to potential recidivism. The court can then look at that objection in the context of everything else that's going on in the case: pretrial adjustments, rehabilitation efforts, pro-social lifestyle changes, That's how my court approaches acceptance of responsibility. Many courts in the Second Circuit approach acceptance of responsibility that way, and I think most courts. We think that's a positive change.
Okay.
Thank you, Mr. Chairman. On behalf of the PAG, I'd like to start by presenting a little bit of context for our position. Probably one of the most difficult, most fraught interactions we have as defense attorneys is discussing with a client what it means to plead guilty and accept responsibility, for conduct, for its conduct, and at the same time maintaining credibility that we're going to zealously represent them in sentencing as regards guideline issues. And it's in this context that the issue of relevant conduct is reigned and very problematic. The PAG reports, somewhat corroborating what we just heard, that in a significant number of guilty plea agreements and resulting sentences in some districts, that these are influenced by the perceived risk of losing acceptance credit if the defense makes good faith, legitimate, legal, and factual challenges to the government's description of the conduct. And so the defense lawyer has to then balance the potential upside of bringing good faith arguments against conduct believed to be irrelevant or legally inconsequential, balance that against the risk of losing acceptance credit. And so it's that chilling effect resulting in plea agreements, resulting in sentencings, which are not going to reach the Court of Appeals and be challenged. Then you throw in the appellate waiver to further explain the lack of case law in this area. And so one answer, Chairman, prior to your question about what's the difference between the old language and some version of the new language, is there may not be a lot of difference, but just the fact of changing the language, given this existing problem, will signal and reassure and provide a platform that will be less chilling for the defense. The dilemma, by the way, arises in a whole bunch of contexts. We've heard about some of them: drug amount, loss amount, use of a firearm, leader organizer, arguments about mental health, arguments about the influence of others on the defendant, proximate cause of injury. All of these things kind of roil into the relevant conduct issue. So the PAG supports the proposal that 3E 1.1 should be clarified or modified. We believe the proposed wording should be modified to eliminate ambiguity about challenges to relevant conduct as a matter of law, however. Option 1 and Option 2 really blend law and fact together. Option 1 says a non-frivolous challenge to relevant conduct is not precluded from consideration for an acceptance reduction. While that wording does affirmatively acknowledge the right of the defendant to make a good faith factual challenge to relevant conduct, the PAG thinks it's important to acknowledge that challenges to relevant conduct may be legal and should not be subject to this non-frivolous standard. Why do I say that? Defense counsel have an obligation to zealously represent their clients. Reasonable lawyers can disagree, obviously, on the merits, and the law evolves over time when we're able to raise novel issues and preserve them for appeal. And perhaps most importantly, or most dispositive in the context of this discussion, a defendant's eligibility for acceptance of responsibility should not be tied to the perceived quality of a lawyer's legal argument. That says nothing about the client's acceptance of responsibility. So we would recommend modifying the language something like a defendant who makes a legal challenge or a non-frivolous factual challenge to relevant conduct is not precluded for consideration for a reduction. That accords defense counsel broad deference to assert aggressive and creative legal challenges to relevant conduct without causing their client to lose or risk losing acceptance credit. Thank you.
Judge Pryor and the Commission, thank you again for this opportunity to speak on behalf of the Victims Advisory Group. As we have heard from the first panel and my distinguished panelists today, the Commission has recommended two options, and I will tell you that the Victims Advisory Group does not support either for a couple of reasons. First, under the first option, the defendant may make a non-frivolous challenge to relevant conduct without affecting his ability to obtain a reduction. appear non-frivolous is not defined, nor does there appear to be sufficient evidence that, in our opinion, support that this is a general issue. With regard to the second option, which the VAG concludes is more expansive, it will allow the defendants to challenge his conduct provided they produce an arguable basis. Again, what is an arguable basis? That's what lawyers do. They argue. This, again, is vague. Both options present a situation where the victim has yet again have to testify, and in this case, in a post-conviction mini-trial regarding the defendant's challenge of an acceptance of responsibility adjustment. I would submit to you that's a chilling effect on a victim to be re-victimized. One of the tools prosecutors levy on behalf of victims, and I don't want to minimize this, is to offer a plea, even when the government wants to go to trial. Oftentimes, a plea is offered to spare the victim from going to court and face their accuser in an adversarial forum. There is no protection in either one of these options to protect the victim. I can see a scenario, in fact, we will see a scenario if there is a change that where every case of a pre-sentence report would be open season to litigate for defendants to minimize their conduct, especially at the expense of many victims. Many times these cases involve he said, she said. Are we going to be in a position to start arguing facts about what happened at the post-conviction level? I think the response to this is better coordination between the prosecutor and the defense attorney. A lot of the issues can be negotiated when two parties sit down and hammer out what is the acceptance of responsibility at that level, instead of carrying it on to a mini trial, which will then open up the victim or subject the victim to cross-examination and perhaps other victimization issues. If the commission is looking to clarify, I would ask an exemption for victims to participate in these mini trial to protect their dignity and then their respect under the Crime Victims' Rights Act, the CVRA. But as written, the VAG cannot support either option.
So, Mr. Bendzunas, if you could just, I think I come at this similar to Judge Pryor, which is, my understanding is that everyone would agree that we want defendants to be able to make legal challenges and, however we're going to use the adjective, good faith, well-founded, whatever the word is, factual challenges as well. And my thought was that's what this is already trying to do, but in some places has been interpreted to mean if you make a factual challenge and you lose, you don't get it. And so that creates the chilling effect. So if that premise is right, that it's just we haven't used the best language to describe what we would like to be able to give defendants the ability to challenge in all cases, the question is if we could have better language that allows them to do that. And what I hear the government and Mr. Andrews saying is if we somehow made the language better, it might open a floodgate that would require mini trials or having victims come in. And so I guess what I'd like to hear from you is it sounds like there are already lots of places in the country that are reading this the way that I thought we should always have it be read, and that our language would just be designed to clarify. So in those places, can you tell me what the practice is actually like? Is it mini trials? Are victims asked to come in and testify? Because we would already know empirically what that world looks like, presumably, if in fact there are places that are already doing this.
Yeah, I think the good news is that a lot of courts are applying acceptance of responsibility as you would like it to apply. There's isolated areas that aren't. But I think we've received a lot of feedback on this. And it's rare to come up with many scenarios where courts are really, U.S. attorneys' offices where they're really aggressive, but they're out there. And it is a problem in those areas. We do think that option 2 is the preferred option. We just want to find a way to provide some level of safety for a defendant to reasonably contest relevant conduct, and not just losing acceptance is a big deal. It's a 25% increase in your sentence, and in some places, I think people are being leveraged to silence.
But where they are contesting it, the places that you know, what does the practice look like in those
Oh.
places? Because the fear is that, it's going to be too much process and it's going to undermine the reason that we can, one of the reasons why you have.
Yeah, I mean, I could speak for the Second Circuit, and defendants are generally, within reason. When those objections take the shape of a criminal thinking pattern, you might have an issue. But it's normal to have evidentiary hearings that require a couple of witnesses. The right result comes out after that, and the courts generally don't hold it against the defendant.
On that point, don't the probation officers make a recommendation in the PSR as to whether the defendant should lose acceptance of responsibility? So it's not just that you're saying if the government interprets it this way, but it would also be that the probation officers were interpreting it that way because they would be recommending loss of acceptance as well.
Absolutely, and that does happen across the country. It is leveraged within. I've done it myself. You have a defendant trying to resolve a case. We can tailor the issues for the district judge. Acceptance can come into play in some of those instances if someone's going far afield.
So why would that change by adding a sentence that says not based in law or fact?
I think that it just provides some safety. It just comes down to that.
Really, your quarrel is not with current language, it's with certain courts. You're asking us to change, or suggesting we change the language because of a couple of courts. The language is fine. That's what it's intended to do in those cases.
I would tend to agree, but I also look at this through the eyes of one of the defendants that are in those outlying courts.
And my next question would be point to the particular language that is not working in our guidelines.
Well, falsely contest and frivolously deny. I mean, that is.
We recognize that the district court has to have some discretion because it's a highly fact-intensive determination.
I agree, but falsely contest is pretty black and white, as the defense attorney is here before.
Yeah. So a defendant comes in and you see the demeanor, you've heard a trial, falsely contest for a district judge who looks at some kind of factual issue that then comes to the Court of Appeals and we just have a cold transcript. It's not so black and white, right? That's why those kinds of factual issues are reviewed for clear error. Judges who have seen witnesses testify, who eyed the defendant, may say that is false. You know it's false, and it's not something that the cold record would necessarily tell you one way or another that the judge is out of bounds or completely right, right?
Yeah, unfortunately, I think people are getting punished for losing objections. And that's not necessarily the intent of acceptance of responsibility. I'm trying to find a happy medium that provides some level of safety.
You don't think the district judges
I think generally they are.
Breyer? Okay. Thank you very much for your presentations today. As we wrap up, I want to mention an upcoming event, the Commission's National Seminar on the Federal Sentencing Guidelines in San Antonio, Texas, on May 30th through June 1st. This seminar will provide specialized instruction to probation officers, prosecutors, and defense attorneys on the guidelines. Registration for the event is open on a first-come, first-served basis, and many have already registered. Our website has all the details regarding the event and registration. Finally, the Commission will have several publications released in March, as well as another public hearing on other proposed amendments relating to synthetic drugs, including fentanyl, and alternatives to incarceration on March 14th. Before the hearing, I encourage all of you to review the data presentation on synthetic drugs posted on our website. We appreciate the broad interest in our work and look forward to our next public hearing. Thank you very much.